One sunny morning, while you were about to get your cup of coffee, you were suddenly stopped by a police officer. He invited you to come with him to the police station for questioning. What should you do? Well, there's an answer for that, and that is in Article 3, Section 12 of the 1987 Constitution, or commonly known as the Miranda Rights. It refers to the right to remain silent, to have an independent counsel, and to be informed of such rights when you get arrested.
These rights can only be used if you are under custodial investigation. It is simply when you're questioned by police officers or law enforcement authorities after being arrested or deprived of your freedom. A general inquiry or police lineup for identification of the suspect is not a custodial investigation, and the Miranda rights cannot be applied. But if a person is particularly suspected for the crime of rape and is arrested and brought to the police station for questioning, he is now protected of the Miranda rights. Custodial investigation is initiated by a law enforcement officer. A ticket clerk in an airline company called by the employer for questioning is not under custodial investigations. It is custodial investigation when one has been taken into custody or deprived of his freedom to get a confession from him about a crime. Someone who voluntarily confessed in an ordinary manner cannot invoke the Miranda rights as he did it spontaneously and not under a custodial investigation. Take note that custodial investigation is not the same as preliminary investigation. Issuing an invitation to a person for questioning is already an effective custodial investigation.
The right to remain silent. A person under custodial investigation has the right to refuse answering any question conducted with the police officer. If he or she refuses, this may not be used against them. The right to competent and independent counsel. This right gives you an opportunity to be represented by a lawyer to avoid extracting a confession that leads suspects to make self-incriminating statements. Competent counsel must be effective and vigilant. It is required by the lawyer to be willing to safeguard the constitutional right of the accused. Public or private prosecutors, the police, and municipal attorneys are not considered independent. However, retired members of the aforementioned are considered as such. The right to counsel starts at the beginning of an investigation. The right ends when the investigation is over. The rules do not apply to persons under preliminary investigation or those already charged in court for a crime. These are the steps that must be performed. The accused must also be informed that he or she has the right to be given a counsel if he or she cannot provide one or pay for one. The right to be informed of such rights. To be informed implies an obligation on the part of the police investigator to explain the rights. They must use plain and simple words when informing you of your rights. They must explain what you may or may not do. They must consider that you understood the consequences of your waiver. They must be certain that you understand your rights before proceeding to the next process. These are the things that the police should not do when informing you of your rights. They must not spare any details when explaining your rights.
You must be informed that if you decided to waive these rights, it must be done in writing and in the presence of an attorney. Meaning, if you do not follow the instruction that your waiver must be in writing and must be made in the presence of a lawyer, it is not valid. Any confessions obtained from you without your lawyer cannot be used as evidence against you. You must be informed that you can still invoke these rights anytime during the process, regardless of whether you have already answered some questions or volunteered some of your confession. You must also be informed that any statement or evidence obtained in violence shall be inadmissible in evidence. Now that you know some of your constitutional rights, let us also learn what we call the exclusionary rule, or commonly known as the fruit of the poisonous tree, meaning evidences illegally obtained to convict you and make you guilty of the crime you committed or did not commit. What will you do? You need to file a complaint about this and prove that you were really abused, tortured, threatened. You can prove it by physical examination. It will reveal the truth of the injuries that you got. However, if it is not in line with what you claimed, all of those will be presented in court as evidences against you. And rest assured that you will be found guilty and spend your time in jail.